Thank you. I rise to speak on the South Australian Public Health COVID-19 Amendment Bill 2022. The bill seeks to amend the South Australian Public Health Act 2011. I felt a strong moral and ethical responsibility to our constituents to speak on this matter, but also a strong responsibility to ensure, to the best of my abilities, that any legislation had proper deliberation and care for all South Australians. The proposed amendment bill is in part a positive development in that we are moving away from direction by unelected bureaucrats to a more cabinet-based model, and directions will only relate to those who have tested positive for COVID-19 and close contacts, although close contacts perhaps warrants a firmer definition. Additionally, it does have an expiry date of 6 months, which may be appropriate depending on the inclusion of safeguarding legislation. However, I do have some concerns with regards to the proposed amendment bill in relationship to protecting public liberty rights and ensuring there are proper constraints on enforcing officers acting out directions. I also have concerns over the accountability currently of any directions made. The 6 amendments I propose reflect those concerns and would restore proper protection and safeguarding mechanisms. All parties were notified of my proposed amendments last Friday morning, the 13th of May, to ensure a proper time for consideration. Under 90E modifications of Act in the Government's South Australian Public Health COVID-19 Amendment Bill, it states that if a public health incident or public health emergency is declared, the following provisions do not apply. Section 14, subsection 6, 7, 9, Section 90, subsection 3, 4 and 5 of the Public Health Act 2011. All sections here proposed for removal by the government relate to safeguarding legislation for public liberty rights and safeguarding legislation to ensure proper constraints on enforcing officers. They relate to rights of appeal to the Magistrates' Court for review of directions and to ensuring that the reasonably practicable steps are taken to notify next of kin if the liberty of a person is imposed. Section 14, subsection 9, marked for removal, is of particular concern, as I feel strongly that if, for example, a 15-year-old were to have their liberty restricted, then all reasonably practicable steps to ensure a nominated person is informed should definitely be undertaken. Also of importance is the proposal to remove the requirement of an enforcing officer to consider if an individual should be managed under the Mental Health Act 2009. I have 3 amendments aimed at ensuring the same principles currently reflected by the safeguarding legislation in the Public Health Act 2011 remain enshrined for COVID declarations. I've consulted various legal sources and I've been assured that these principles, as written in my submitted amendments, are practical and are reasonable for COVID declarations. Amendment 1 and Amendment 4 express the same requirement, and they are requested at 2 places in the bill to ensure their application both to the directions by the Governor, 90B, and enforcement of directions, 90C, and to ensure their application at 90E modifications of the Act. The second insertion is important to ensure their application specifically to any declared COVID emergency. These 2 amendments will state directions restricting the liberty of a person should not be applied unless reasonably necessary, that if the department is aware that a person is vulnerable, such as an elderly person or a younger person, all practicable steps to ensure that the person's next of kin are informed will be undertaken. That if the department is aware that someone might need to be considered under the Mental Health Act 2009, that they will receive this consideration or other assistance or counselling would be provided to that individual. The 5th amendment I propose is consistent with the existing appeal provision of Section 90 in the Public Health Act 2011. It ensures the right of appeal to the Magistrates' Court for the individual, and I have also requested an addition at 14 to ensure that were an individual unable to attend the proceedings, that reasonable steps are undertaken to provide the person with an audio or audio-visual link to the proceedings. The next 2 amendments relate to ensuring transparency and accountability of any directions given. Specifically, my 2nd amendment allows governors' notices to be made disallowable the same way that regulations can be made disallowable, and the 3rd amendment requires reporting of how any delegated powers are undertaken. It's important to give further context to my above 5 proposed amendments to protect safeguarding measures. The government desires to retain in the proposed amendment bill the powers allowable by the Emergency Management Act 2004. The government's proposed amendment bill states under 90C enforcement of directions that an emergency officer may exercise any power referred to in section 25 subsection 2 of the Emergency Management Act, and it's pertinent here to visit some of those powers which state that the state coordinator or authorised officer may enter, break into land, buildings, structures, vehicles, remove or destroy any building, structure, vehicle, animal or thing, that a person may be submitted to a decontamination procedure, remain isolated, segregated from other people, directed to undergo medical observation, diagnostic procedures or treatment, amongst other powers. Although under an emergency these powers may be needed, in my view it is not appropriate to retain these powers while removing necessary safeguarding legislation. My 6th amendment relates to removing the word apparently from line 20 under Schedule 1, Transitional Provisions of the government's proposed bill, and I do question why the word apparently has been inserted here. It states relevant direction means a direction or requirement apparently in force, and I have had legal advice from various sources informing me that the insertion of the word apparently here serves to undermine legal action in the courts with regards to the legality of vaccine mandates, and for this reason I request the removal of the word apparently. So in closing, I do support the movement away from the management of the COVID pandemic under the Emergency Management Act 2004 in principle, and I support a return of law-making powers to the South Australian Parliament and a cabinet model. However, I have concerns regarding the accountability of directions, proper safeguarding legislation for the public in the amendment bill's current form. The details of this bill do warrant very careful consideration due to the possibility of their permanent entrenchment in our legal landscape and their potentiality to undermine action in the courts.
No, you're going to sum up?
Oh, he's sum up, and we're going through.
I can't see.